All right, we're back. Good afternoon to some of you, still good morning to others. Hopefully you enjoyed our morning conversations. We're gonna get going with some more conversations this afternoon. We are in a meeting format for the rest of the day, so that means you can unmute yourself. You did come in as muted. You can unmute yourself and ask questions, and we'll definitely make sure we take a lot of pauses. You can also put questions in the chat or in the Q&A, and we'll be monitoring that as well. So let's get going here. Just hopefully you enjoyed your office hours this morning. I think most of us found it, or at least staff side, thought it worked pretty well. So maybe that's something we can continue to think of maybe as a training option for all of you. But I just wanted to put that up just in case you needed a name for one of the staff that went with it. I know we had a very active Saver Makers Treasures conversation, so it was good this morning. And then this is where we're headed today. So we've learned about disaster. We're going to move away from disasters and talk about some other things. John's going to do a quick talk he does on the hierarchy of law, which he has managed to instill in me over many, many years, the importance of that. And he gets very excited when I quote things like today I said statute so many times, and that's because of John. So he's going to give us an overview of that. And then talk about some other issues that we've had come up in this past year with laws and regulations. And again, we're gonna go back, and if you didn't have time, maybe try to skim over the FAQ document that was in the agenda that was sent out, the link to it, to see if there's any of those frequently asked questions that you'd like to talk more about, and we'll have some time to do that. Then David's gonna talk to you about ordinances. We've kind of brought that up in conversation along the way. But some specific things that he's run into, and I think he has a state that might share an example of what they're dealing with. I think it was New Mexico, so heads up there. Then we'll take a 15-minute break and come back in the afternoon to talk about CLG subgrants. We're going to go over some guidance, talk about COVID issues. James is going to show you what's up to date in the HPF online, and then talk about how to update your contacts and things like that. And our last piece of it will just be kind of open discussion if you want to share some of the great things you've got going on. And we can take it for as long as we need it, because I know you guys want to have time to talk, because that's one of the more important things about all of this. So with that being said, I'm going to turn this over to John for hierarchy of law.
Hello, everybody. It's a good day to you all. I hope you are enjoying the meeting so far. As Megan said, this is going to be a very brief presentation. We have an audience made up of experienced folks and people with a little bit less experience. But I'm going to go through everything quite briefly to maximize the amount of time that we have available to discuss. Now, hierarchy of law, which actually what that means is how our various foundation documents relate to each other. Why do we care about the hierarchy of law? Well, if somebody comes to you, let's say it's a city attorney, a property owner, state legislator, and wants to know why you are doing the things that you do in your certified local government program, a response that says that we're doing it this way because this is the way we've always done it is not a good enough response for anybody. We need to be able to link our activities to our foundation documents and know how our foundation documents relate to each other. Next slide, please, Megan. Okay, here we go. From top to bottom, in order of importance, starting off with the National Historic Preservation Act, all the way down to oral guidance. And in each case, the top one is, at the top, it's the most important. It's generally the most general guidance. And it also goes, so from top to bottom in terms of increasing level of specificity. You would expect there are policy guidance like the HPF grants manual to have more details than it takes place in the National Historic Preservation Act. That's the way we want it. It's hard to pass statutory law, nor do we want the Congress to get into too much detail about things. It also is in order not only of importance and specificity, but flexibility. That it's very easy to, or relatively easy to change policy in our grants manual. It's extremely hard to change the National Historic Preservation Act. Let me talk a little bit about, oh yes, and therefore, there's a hierarchy. These are all linked to each other so that all the government-wide regulations, the program regulations must be based on and consistent with the National Historic Preservation Act. What's in our grants manual must be consistent with what's in our regulations, and so forth and so on. Any policy that is inconsistent, anything in our grants manual, any letter, any oral guidance that is inconsistent with what our regulations say and what the Act says will fail if challenged. Flip side is true also. If there's a change in the Historic Preservation Act, the statute, our most important statute, that automatically supersedes anything below that that's inconsistent. Let's talk a little bit about waivers too. We do not have, nor does anybody else, have the authority to waive anything that's in statutory law. And that's part of the reason it's important for you to know what's in the statute. In our regulations, we have given ourselves the ability in rare circumstances to waive regulatory requirements as long as they're not statutory. And so anything that we do that is explicitly tied to the National Historic Preservation Act, we do not have the authority to waive. May I have the next slide, please? All right, little sidebar here. Want to talk to you a little bit about the new Preservation Laws book. Technically, it's entitled the Federal Historic Preservation Laws book. There's the link to it. And you'll find the link in the frequently asked questions too, so you don't need to write any of this down. Now, all right. Oh, I want to do I'm going to make life a little bit difficult for Megan. Can I go back a slide? Very good. In all these foundation documents, who has the authority to interpret them? Who has the authority to interpret the Act or the regulations or what's in the HPF grants manual? Yes, the courts have the authority to interpret this, but I want to talk basically about how interpretation works in our administrative framework, in our CLG program. Essentially, the way the Park Service policy is on this, if you have a question about how to interpret something, you would look at each one of the foundation documents. You would look at the Act, you'd look at the regulations, you'd look at the grants manual, and any written guidance we have provided. If a particular situation comes up, as it will, that is not mentioned anywhere, you in the state office, as the co-administrator of the CLG program, have the authority to interpret all written guidance and requirements that the Park Service has provided. We'd like you to talk to us, but our basic policy is that as long as you come up with a reasonable interpretation of the Park Service requirements, the Act's requirements, we will back that up even if it's not the only possible reasonable interpretation. We cannot and will not hold anybody responsible for or accountable for guidance that we have not provided. So as long as you do a reasonable interpretation, you're in good shape. All right, next slide again, please. And I want to give an example of that reasonable interpretation from the National Historic Preservation Act. The regulations, well, you all know, to become a CLG, you must meet the statutory definition of local government, which is generally speaking a general purpose political subdivision of a state. Well, what does that mean? The Park Service does not have the ability or the policy it is our policy. We leave that up to each state to determine what a general purpose political subdivision of your state means. So if you have a question, then you would talk to your state attorney general's office or somebody else who has the authority to guide you on this, and whether a particular local entity meets the state's definition of a general purpose political subdivision. As long as that's a reasonable interpretation, you're good to go. And I just use that as an example, but that's true for interpretation of all of our foundation documents, the statute, the regulations, what's in the grants manual. Now, let me shift over to the Historic Preservation Laws book, brand new. And there's the link is there for our online version. Each state office has received their own hard copy of it. I want to say a few things about that, just so that you can be aware of. This Federal Historic Preservation Laws book is different from all the previous editions. Here's why. Since the last edition, you may have heard our discussions. You probably know what Title 54 of the US Code is all about. Prior to 2014, the US Code, which means the United States Code, was a compilation of all laws. The actual law itself was the National Historic Preservation Act. So the laws book has always been set up to allow preservationists and lawyers to talk to each other. It is organized, each act in the law book, including the National Historic Preservation Act, is organized the way we preservationists think of it. Like Section 108, Section 106, Section 301, all those kinds of things. And with annotations to where you can find that information in the United States Code. When Title 54 was created, they changed the rules. Title 54 now is the actual law. So when they created Title 54, this is the point I'm getting to, they changed the wording. They did not change the meaning of the National Historic Preservation Act or any other act, but they changed the wording. So if you have older versions of the Federal Preservation Law book and you're interested in quoting the language, this is not the place to go. Get rid of the old books. The new one has the language that comes directly out of Title 54 with cross references on where to find things in the US Code. That's point number one I wanted to make on that. The laws book, it's current now. It will not be current forever. We, on average, if past is prolonged, we have the opportunity to update this every, 5 to 10 years or so. The US Code, however, is always updated. So if you want to make sure that you're looking at the current language, this current statutory language, the National Historic Preservation Act, you need to go to the US Code. And the citation is there. And in the frequently asked questions, we provide some guidance on how to find it and what parts of where to find it online and what parts of the National Historic Preservation Act are most important to the CLG program. All right. Okay. Let's talk about that, Oh, yes. In terms of usage of names, these days, because of the new setup, you no longer need to say the National Historic Preservation Act as amended, or the National Historic Preservation Act of 1966. If you say the National Historic Preservation Act of 1966, you are technically referring to the way the act has looked when it was initially passed in 1966. And that was before there was any CLG program involved. The National Historic Preservation Act has been amended more than 25 times since it was initially passed. But because the US Code is automatically as amended, you don't need to have that in your citation. All right, next slide, please. All right, regulations. I want to, excuse me. I want to talk a little bit, and regulations is a good example of purpose sections and definitions. Actually, I'm going to do this to you again. Megan, can I go back one more? Thank you. This applies to all. No statute, no regulation, no policy guidance can possibly anticipate every possible scenario. Therefore, it's important for you to be, when you're looking at your foundation documents, to always look at the purpose section. That will give some guidance for the general intention of Congress or the National Park Service and what we intended for that particular foundational document. And that will help you make choices in how to decide how to answer unanticipated questions. Also want to talk a little bit about definitions. In the National Historic Preservation Act, you might think you would find all the definitions in one place. You would be wrong. There are the location of definitions, and this is especially pertinent for the Certified Local Government Program, are found in two different places. And this is all, where those are is all explained in the FAQs. The definition for designation and protection is located in the section that has the general requirements for the CLG program. And that's because those definitions only apply to the CLG program. There's a more general definitions section, which includes definitions of local government, certified local government. Those are all together and they apply to the act as a whole. So generally speaking, when you're looking at a foundation document, you need to look for the definition sections, and where they are located will tell you the extent of their application. What you need to take from this is that the designation and protection definitions only apply to the CLG program. All right. Now, forward again on to regulations. Okay. The regulations for the CLG program, that's in 36 CFR 61. And regulations are a little bit different from statutes. In the frequently asked questions, we will give you 2 citations for how to find the information you need to know about our regulations. When regulations are issued, they are published for effect in the Federal Register. And part of that publication is an explanation of all of the comments that were received on the proposed regulation and why the Park Service, in this case, chose to take or not to take some of the suggestions. Once that is published, then the regulations are codified into the CFR, the Code of Federal Regulations. That introductory material, so why the Park Service took various positions, is not included in the CFR. Therefore, if you are interested in finding out why the Park Service took its positions on various topics covered by the regulation, then you need to go to the Federal Register citation, not the CFR citation. Okay. Oh yes, regulations. Our regulations have been around for a long time. This is how you can tell if your regulations are, if your copy of 36 CFR 61 are out of date or not. If your copy of 36 CFR 61 has anything called appendix on it, appendix A, what you have is out of date and ought to be tossed. On to the next slide, please. Okay, this is to help illustrate one of John Renaud's pet peeves, the use of the word standards without explaining what that means. Now, these are all, you see all the listings there. These are the Secretary of Interior's standards and guidelines for archaeology and historic preservation. These were last published as a group in 1983. Some of these parts have been updated. They are advisory only. They are the Secretary's best advice on how to deal with certain historic preservation situations. They become required, it takes a separate administrative action to give them effect. So for the Secretary's standards and our programs, the HPF programs, all the programs that the Park Service administers, our regulation adopted and adapted the Secretary's standards, but not the guidelines to be part of how we operate our grant programs, our CLG programs, etc. Back to my pet peeve. Each listing you see here is a Secretary's standard. So it is important when you are talking to somebody to explain when you say the standards say this, to let folks know whether you are talking about the treatment standards or the rehab standards, or another project I'm working on, the professional qualification standards. And I want to talk about really briefly about this project because it's an active project that's going on and right now, and we're making really good progress. All right. The Secretary of Interior's Historic Preservation Standards and Guidelines have not been updated since 1983. What the revision is intended to do is to have standards and guidelines for every discipline that the National Historic Preservation Act mentions. Unlike what was the case in '83, there will be guidelines for each discipline. These are all disciplines as they relate to historic preservation. So having knowledge or expertise in a discipline without appropriate knowledge and expertise in historic preservation is not good enough. These all relate to resources, and the revisions make clear these relate to resources that are likely, that the users of these standards are likely to come across. It's important, and the proposal to change this too, to know that the standards, there's professional qualification standards by themselves, because they are national standards, have to be broad enough to apply everywhere. That means they're not specific enough to apply to individuals, situations, jobs, positions, and so forth. So we make a point of saying it's important to customize when you do your RFPs, when you're looking for somebody to take on a role or a position, that you customize what you're asking for the kind of resources that the person is likely to be able to want to deal with. And finally, we are writing these professional qualification standards, not just for us folks who work in historic preservation, but for anybody who has an interest in knowing how to determine whether somebody is a good fit for what they want done in historic preservation. The average reader is not going to read the entire document. The average reader is going to go to a discipline in which they have some interest, and it's important that the standards and guidelines make clear what they need to know right in that place and point them to any other places for which they need to get the knowledge. Now, this is a departmental document, which means once we are ready to go, this will require not only Park Service approval, but departmental approval, both for products, both for programs and disciplines, but also for the legal end of things. We are just finishing up right now. We have had the invaluable assistance of Carla Maddox, who is a individual who retired and used to work for the solicitor's office to help make sure that our explanation, what our proposal is clear to everybody. And we're just finishing up that review right now. The goal is to get this published in the Federal Register for review and comment. I want you all to know that everybody will get an opportunity to look at this and make suggestions. So that's sort of where we are now on the professional qualifications. Next slide, please, Megan. All right. Grants manual. Easy enough. Once again, oops, I spot a typo. Anyways, once again, the frequently asked questions will tell you where to find the parts of the grants manual that are important for you as a coordinator of the CLG program. Next slide, please. All right. I want to talk a little bit about the frequently asked questions. Where did they come from? Well, in recent months and years, we get a number of questions from all of you. So we answer the questions, but the word doesn't always get out to everybody. So we need to thank you for coming up with the questions. And the frequently asked questions, the FAQs, are those for which we think there is a fairly settled position from the Park Service point of view. Let's see, I want to talk about that. They are, you have received the draft of the FAQs. Again, they're draft. So anywhere you see where we can use some improvement or add some FAQs, we would very much appreciate it. These will be used to inform and help out Johnny in the revision of Chapter 9 of the Grants Manual. And these will also be helpful to put on our CLG webpage for the general readers who want to know more about the CLG program. What I'm going to do shortly is to walk through the topics of the FAQs, but I'm not going to go through all the answers because you are all wonderful readers, and we can discuss these in more detail if you want. My one exception, and I don't know if it's possible to pick that up, is the frequently asked question number 13, which has to do with National Register listings and CLGs. So is that something that we can pick up, or should I just keep on rolling?
John, why don't you keep on rolling, because it's a little switch back and forth.
Okay.
And I think we all know what you mean by that.
But some basic points I want to highlight here. This is not, when we talk about local governments, local ordinances, making local land use decisions automatic based on listing in the National Register. Some points that need to be made. We, as Megan has mentioned several times already, we no longer approve new ordinances, new CLGs that have that automatic connection. this is more than just local designations. We have seen some cases where a local ordinance made property owners subject to design review automatically without going through any local designation process. So the problem of the automatic connection is not just designation, but it's everything. There are, for the CLG program, backspace a little bit, there are, an automatic connection has a big potential for political danger. I'm not going to mention the state, and this is several years ago now, but there was a case in which a local government made property owners and properties subject to design review automatically upon listing in the National Register. As it happened, there was one very unhappy property owner who happened to be the major financial contributor to the member of Congress who headed up the Park Service Oversight Committee. And this member of Congress proposed changes to the National Historic Preservation Act, including major changes to the CLG program, including taking out the "or eligible for" language out of Section 106 of the Act. It was a big problem, took a lot of work to undo it. There are risks involved in having this connection. Fortunately, for the CLG program, we have some statutory references about why this cannot be done. One of the statutory requirements for becoming a CLG and maintaining CLG status is that the local government have adequate levels of public participation for all elements of the local program, not just the National Register program. And since, because decisions made of local designation have different consequences than being listed on the National Register, there needs to be a separate opportunity for the public to weigh in, a public participation. Without that, it will not fly. Similarly, also statutory, if you happen to be a CLG, the CLG in question or the ordinance makes the property subject to design review, and the property owner knows that upon National Register listing, all the property owner has to do to avoid that is to object to the National Register listing. That way, by objecting to the National Register listing, they avoid the local consequences. This chilling effect on National Register nominations is contrary to SHPO responsibilities that the Act describes and to the Park Service directions in the Act to maintain and expand the National Register. Next thing I want to be clear about is what we are speaking about here is the listing, not the information that is provided in the listing. It is perfectly reasonable for local governments to take information that is included in a National Register listing and use that as part of their decision-making process for whether a property should be locally designated. The other rationales just make sense, and you can read all of those. And that is what I'd like to do right now is a quick walkthrough of the topics that the FAQs talk about. I'm not going to go into any of the answers. We can come back and talk later. There are a number of FAQs all about where you can find things online that you need to know. And in very long documents like the Act or the HPF manual, where you can find things that relate to the CLG program. There's a question about whether conflict of interest rules apply to CLGs. Short answer is yes, you can read all about it. there is, okay, can't talk about that. Okay. FAQ on who needs to and is authorized to sign off on certification agreements. FAQ on tribal participation in the CLG program. Can they? Can they be a CLG? Can they take on a CLG program if they're a THPO? Can multiple jurisdictions make up a single CLG? We get that one a lot. All right. We talked about that. Oh, yes. Counties. What is the extent of the county CLG jurisdiction, and to what extent does that need to be reflected in the certification agreement? All right. Oh, yes. Most of you will be familiar with the National Register role that the CLGs have. If both the chief elected official and the CLG commission agree that a property is not eligible for listing on the National Register, the State Historic Preservation Officer is forbidden from taking any other actions subject to appeal. But that appeal needs to be done within 30 days. How do you let people know all about that? And there are other topics that we can go on, but you can read those topics. We can come back and talk about all those, and we can come back now. Are there any questions I should answer now, or do we want to turn to David for his little presentations, and so we can get into general discussions?
Well, Don, why don't we see, does anyone have questions about the topics in the FAQ? And John summarized a few of them for you. Now would be a good time to maybe ask those. And we do have one in the chat that I can start out reading from Pete. So this is a law regulation stumper, and I have this feeling you can't stump John, but there's a potential proposal to list a county-owned property located in the city on the National Register. The city is a CLG and the county is a CLG. Which CLG, city, county, or both, needs to review and comment on the nomination? And if one or the other objects, what happens?
All right. The answer is that a CLG's jurisdiction covers those properties over which it has the ability to make land use decisions. So that, for instance, a CLG jurisdiction does not cover federal properties or tribal properties or those kinds of things. So that and that is would often be, so for a county-owned property within a city CLG, you would contact, first of all, your your National Register Coordinator and your National Register Reviewer in terms of notice. But in terms of the CLG requirements for the CLG Commission, they have a statutory and regulatory responsibility only to provide information on those properties over which they have jurisdiction. A similar kind of program issue would be, what if you have a property that overlaps jurisdictions? You have a bridge, you have a road, you have a farm complex, and you need to talk on a case-by-case basis with your CLG, with your National Register Reviewer and how that works. But to the extent that any part of a nomination is within the legal jurisdiction to make land use decisions, that CLG has the right and responsibility to make at least some part of an evaluation over those properties which are within their jurisdiction. Is that helpful?
Hopefully that answers Pete's question. I think it does.
That's FAQ also.
Okay. And I just want to be politely pointed out that the link to the law book and the fact sheet is not correct. It has an extra digit. So we will revise that and get that back out to you. And in fact, if one of my team would be willing to put that in the chat, I would appreciate that.
Right. You might, maybe it's right in the FAQ. Might check there.
Hopefully so. Okay,
Double check.
now's your chance to ask John any kind of law and policy questions. Anybody have anything that is stumping them? You know, this is where I go when you ask me the questions. I go to John. So.
I have a question.
Great, go ahead, Vicki.
I tried to type this into the chat box, but I don't know if I was making sense. John, at the federal level, what about those types of ordinances that do not confer automatic designation, but instead deal with things like demolition delay? I know of at least one community in Kentucky. It's actually a county. It's not a CLG, although there is a CLG in the county. They recently lost a very historically significant farm. And they're interested in looking at the idea of some sort of demo delay ordinance for National Register listed properties that would allow a period of time to pass before the demolition permit could be issued in order to try to find a preservation solution.
All right. We have not directly addressed that sort of thing. I think it's worth discussing. My off-the-cuff reaction is that you are making that property and property owner subject to a local provision without any separate public participation based automatically on a National Register listing. So that it's essentially what's understood there is that any National Register listed property in terms of demolition delays are treated as though they are locally designated, and it would have the same kind of chilling effect in terms of National Register nominations. If you knew that your property would be subject to a demolition delay merely by the nomination going forward and being listed in the National Register, you might object to the National Register listing. And so that's my off the cuff, but I think it's worth talking about amongst ourselves to see how you would deal with it.
Thank you.
Vicki, I think DC actually has a pretty kind of streamlined process for if a property is not designated locally, they can put it on a list, like a watch list, and then to prepare a nomination for it. But I would think others might have some suggestions on how you might handle this problem. Does anyone have something they want to share?
So yeah, I put this in the chat, but I know that Nashville has a automatic demolition delay program for buildings that are pre-1860. So it's tied to just dates alone and not any other criteria. Although I think the National Register nominations are often used to determine those dates and things. But for what it's worth, I put in there, it's not a particularly successful program. I don't think it's ever actually worked to ultimately save a building from being demolished.
Phoenix also has a automatic 30-day delay for any building over 50 years old, any commercial building over 50 years old, which basically means someone at the city of Phoenix will call the property owner and say, hey, you know, we think this might be eligible. Would you like to look at tax credits or something else? And usually they say no and it gets torn down, but it's there.
For what it's worth, Philadelphia was very interested. There were some advocates in Philadelphia who were very interested in trying to do what you just described, Vicki, where a National Register listed property would be subject to this delay. And for all of the reasons that John laid out, I pushed back very hard and said, just leave the words National Register out of your mouth when you're trying to make that distinction. But what I think kind of pointed out to them was that so many of the listed properties in the city were within districts. And so, and many of those districts overlapped with, the listed districts overlapped with local districts. So when you actually looked at the number of individually listed properties that were outside of a locally regulated district or an individual landmark, there was like 300, and 150 of them were school buildings owned by the city. So the universe of properties that would have actually been like, you know, covered by that delay provision and not some other more effective law was like 150 properties out of 500,000. Now that's a different scale than probably what you're talking about, but it just was like the numbers like didn't justify the legal vulnerability that the city's lawyers even picked up on.
And I'd like to throw out one extra thing for you all to think about here. To a certain extent, it's relatively easy to deal with prospective local designations and so forth. What do you do if somebody comes to you or you're looking at an old ordinance that has provisions that are not in compliance with current policies? How do you deal with those? Does the Park Service even need to have a policy like this? Is this sort of like what Ruben was talking about yesterday? Is this a sleeping dog issue that you deal with on a case-by-case basis? So in thinking about these various things and the topics that David will lead us all on to is, should there be a Park Service policy on it or not? And if so, what kind of approach should we take in all this based on your own experience? Maybe these are sort of case-by-case situations, but I wanted to throw out there the idea of old non-compliant things. And as my old law professor said to us long ago, that if nobody sues, you don't have a problem. So it's an issue about your level of comfort with potential legal liability. Okay.
I think the driving force in this particular situation is that the county does not have historic preservation staff. They kind of modeled their idea on a much larger city ordinance that, again, uses a date, as some of you mentioned in your examples. You know, any building 50 years of age or older gets kind of a special review, or at least has someone look at it to determine whether the delay is applicable. But this particular county does not have that expertise on their staff. And so I think they're looking for the quick and dirty way to determine what's significant. And
right. And it's perfectly all right. There are a variety of ways to provide adequate public participation. That's not defined anywhere. But so as long as there is an opportunity to participate, maybe in the development of an amendment to an ordinance, maybe in development of amendment to design guidelines, or those kinds of things, there are various mechanisms which would satisfactorily meet the rather vague definition of what adequate public participation means. There just needs to be an opportunity, as long as it's reasonable and it's not contrary to any explicit written guidance of the Park Service or that you guys have provided in your state procedures or your certification agreement. As long as it's a reasonable alternative, even if it's not the only possible reasonable interpretation, it should be okay.
okay, thank you.
You're welcome.
New Mexico has somewhat addressed this in terms of stating directly that the Park Service will not approve a CLG that is doing auto designation of NR for the local level. So we state that outright. And then we also make a recommendation for the existing communities that have those provisions in place to be thinking about redoing their ordinance and designating locally by 2024. So our recommendation is for 4 years in our currently revising state procedures. So we're still working on it. it hopefully will be up on our website soon. But we wanted to be really clear about that as part of moving forward. We will not be approving CLGs that do this, and we want those that are doing this to change, and we're willing to help you to do that.
Carla, what's been the experience with that? Have you had a lot of pushback? Because you have gotten.
Well, since it hasn't been, the final document hasn't been established yet, the draft did go out to all of the CLGs, you know, per our recommended process to approving the state procedures document. No one said anything about these things. Of course, there were literally no comments from CLGs about anything in the state procedures, which is surprising, other than the fact that we changed that the match would be at the discretion of the SHPO. They were glad about that. That was the only thing that they really focused on. So yeah, so the document hasn't been finalized yet.
Okay. And Carla had kind of the thought to tie, it's time to change this to your evaluation period, right? So by the time you evaluate, you're hoping to see a change.
So one of the communities that was a CLG, I completed an evaluation last year, and then that evaluation coincided with a meeting that our staff had with the community regarding a sidewalk project that was being state funded, which meant that it would need to comply with state preservation laws. So that's also a challenge in our state too, is that we have state preservation laws that are similar to Section 106. And so we met with them, and then I followed up with the evaluation paperwork, and was really careful about how the documents were worded, and had the SHPO review everything to make sure that we were just trying to gently let them know that you are reviewing in our properties and you can't do this anymore. And we were recommending 4 years that you make the changes, and they said, well, we're doing fine, thank you very much, and then stopped being a CLG, and then requested decertification. So they're continuing on with reviewing and our nominated properties, but they're just not a CLG anymore.
Here in Florida, we've included in our most recent checklists when we review ordinances to make sure that nobody, at least none of our new CLGs, does automatic designation, because that's a huge problem down here. We have a lot of early legacy CLGs that were certified in the 80s through the early 90s that do include those provisions, and they are incredibly problematic. I regularly get phone calls of people asking, well, how can I remove my property from the National Register because they're trying to get out from local design review. And I just go through the, essentially outline from removing a property from the National Register that comes out of the NR regulations, and none of them apply, and say, I'm sorry, I can't do anything for you. I don't make the rules for that instance. And then I have to refer them back to their local government. And we've been, in all of our trainings, we've been repeatedly advocating that to our local CLG contacts, that they really need to either try to get rid of those provisions or revise the ordinances if they exist. But we even have more problematic issues where we have demolition review that some communities do for properties that are simply documented in our master site file, where there is no public participation in that, because anybody can just walk down the street and fill out the site file form and submit a photo and a map, and bam, that property's in our master site file. The only requirement is that it should technically be over 50 years of age. And now the local government, if they have a copy of that form and has that provision in their ordinance, has review authority over it. And we got dragged into a legal fight in one community because of that. And our SHPO, unfortunately, made the decision to have a property removed from the master site file just so that we wouldn't get dragged into a lawsuit, which is ridiculous. I'm sorry. I am like, the site file should be that database, right, of properties. Removing something from it completely impacts the integrity of the data in that database, because now it's like, well, how reliable is it in a way? So we've been trying to advocate, please don't do that. Please don't do that. If you have it in your ordinance, don't use it.
Right. So part of the discussion in that case is that was the process by which the ordinance that created the master site list and made properties listed therein, was the process involved in making that local rule adequate public participation or not?
Okay, well, we've had a good bit of conversation about
That's
this.
an excellent question. I don't know because it's like,
Wait and see. Okay, John, anything else you have in closing, or we're going to switch over to David and ordinances?
Switch over to David and more about what he does in ordinances.
Okay, we'll keep the conversation going. David, are you ready to unmute and unvideo? Is unvideo?
As far as I can tell, I look like a shadow, but that's okay because I don't want to scare anyone with my face. Please excuse the hat. The hair is picking up in every which way. So I just want to go, some of this is housekeeping. I'm reviewing all the certifications. If the ordinance is not sent, I will ask for the ordinance. But I also, if you send the URL, I can go online and get it and read it myself. So again, I wanted to tell you that, and I'm mainly looking for some of these issues that John has pointed out: automatic listings and national register review procedures. I also will do the decertifications, and as I understand it, we have a draft checklist for this, but if you've gotten a decertification recently, I put in the letter documenting your efforts in getting them back into compliance, but were not successful, and therefore you're requesting the decertification, just so the National Park Service is concurring with what happened. And then there is the issue of recertification. I have drafted a new letter to document the Park Service has gotten the new certifications. And I'd like to ask Corey to talk about Pennsylvania's foray into this.
David, real quick, I think we wanted Carla to talk about kind of the issue we had between the local zoning laws and the.
Yes.
Remember?
I was going to let Corey go first. And then the second issue that I have come across is there is a lot of referencing between zoning and planning commissions and laws, enabling legislation. Some things are found in the certification agreement. Some things are found in the bylaws. So again, I'm looking at all those connections just to make sure there's nothing wild and screwy about it. But in the Las Cruces example that Carla McWilliams can talk about is that there were pre-existing districts, but they weren't really, and Carla, you can correct me if I'm wrong, they weren't really design reviews, but they did have by de facto, one of them did have a design review. So what was that relationship between these designations? And one of them had a review board with the new overall CLG commission. So let's start with Corey on the recertification. And just to mention, Nevada also just went through this.
Okay.
Corey?
Sure. Okay. So I started at the Pennsylvania SHPO in 2011, and I think the second meeting I had when I got there was about revising our CLG state procedures. and we are just finishing up. We just got the last new revised certification agreement back from our attorneys yesterday. So it's been a journey. It didn't have to take this long. There were a lot of kind of hiccups and distractions in between, and we kind of put it down for a little while. But we picked up in all seriousness in the overhaul process in around 2016. And so it took a little while to finish kind of getting our heads around what we were trying to accomplish, getting the documents rewritten, and then going through the full recertification process. So what was driving all of this, though, was, again, prior to my arrival, was this feeling that the program had just kind of lost its oomph. There were 40 some communities participating at the time. Many of them had been around for a long time. The kind of the lust for life was gone. There was a lot of, we were getting the same grant applications from the same communities every year. And it just sparked this bigger conversation about what could we do to reinvigorate the program. So we had to make a couple of kind of key decisions in the beginning of this process. One was, were we just trying to kind of tweak around the edges of our guidelines and procedures, or were we willing to think bigger about a more kind of structural overhaul? And we opted for the latter, because the things that we could do to the tweaks were clarifying some language, maybe making a little bit of some rearranging some sections, but it just didn't seem to kind of get at the reinvigoration goal. So we agreed to think about, to sort of think about this as if it was a blank slate. If we were creating a program to designate and support local governments who took preservation seriously from scratch today, what would we want it to do? Where we sort of settled on was trying to create a program that defined what a good, comprehensive, and sort of well-functioning local preservation program in Pennsylvania look like, and then creating the types of tools and resources that communities needed to both to implement and improve those programs. So trying to shift away from what would have been perceived as just a lot of like nitpicky bureaucratic requirements in the old procedures to something that was more tied to a set of like, no, this is what a good, this is what we would recommend you do, period. And if you do it, and you do it well, then we will give you this, we'll sort of give you this blessing, and we'll confer some benefits on you to help you do it better and do more of it. And the way that we started talking about it was as the preservation equivalent of Main Street accreditation, which was a brand and a designation that had meaning amongst Pennsylvania communities. So I'd say, that every, any community can have like a little revitalization committee or a downtown organization, but if they're Main Street accredited, it means that they implement certain effective practices and they've got certain tools and policies and procedures in place that make sure that they're doing it really well. And that has helped to resonate and make the connection in a lot of communities about what this very bureaucratic sounding designation means to them. So the other sort of important decision we had to make was about whether we wanted the CLG program to be kind of a threshold level, sort of a floor or a ceiling, meaning that did we want to take a very stripped down approach to say, to allowing communities to become certified, following the bare minimum requirements, or were we trying to be a little bit more selective and help, really raise, and provide some aspirational goals. And again, we chose the kind of the latter, partly out of practical reasons. Pennsylvania, some of you may know, has, I think, the second largest number of municipalities in the country. We have over 2,500 units of local government. I think second only to Illinois, maybe. Correct me if I'm wrong. If even 5% of those municipalities had met, if we took a very threshold level approach, stripped down, and even 5% of those communities met that, we would have been completely overwhelmed and had hundreds of potential participants. So on a practical level, we needed to kind of raise the bar a little bit. So we said, you got to do at least something more than just the bare minimum. And then, but then we created like a tier in our overall guidelines that said, but once you're in, because we don't expect you to be perfect, but once you're in, then we're going to create a second set of performance standards. So to give you something to aspire to, something to, some additional things that you want to do after that. And that all of those are things that you could use the grant programs or our technical assistance programs to develop and implement more effectively. So when you see our guidelines, I can pop them on the screen if you want, but I can also share everything that's online right now. My colleague who used to work in Illinois just told me that I'm wrong, that Illinois has half of the number of municipalities that Pennsylvania has. Somebody has more, but I don't know whose state it is out there has more than 2,500. The point is, so we structured our revised guidelines to create certification requirements, ongoing performance standards, and then some recommended effective practices that you could do if you really wanted to be the gold star. And we started by articulating 7 different kind of principles or actions that really effective local preservation programs exhibit, and then listing out the very specific actions and steps that you have to, or tools or things that you have to have in place in order to show that to implement that. So you need to have an ordinance, and your ordinance has to have these specific requirements. And I won't go into the nuances of our enabling legislation, but we had to be a little careful about how we worded things so we could take in a lot of the different variations that we saw at the local level as well. Rural communities, big cities. So we tried to be as sort of functionally written, instead of being very prescriptive and saying you have to have this many or do this kind of thing. We need to say you need to have a law that does X. The last sort of part about this that I think is important here is because we substantially changed all of the procedures and the guidelines. So we totally rewrote the grant part. We lowered all the match requirements. We created some new technical assistance benefits that are available from our staff, things that we don't do for every town, but we will do for CLGs. We negotiated within our state grant program to get bonus points on state grant applications for projects that are within CLGs to give nonprofits and community groups a skin in the game with for the local government's program. Our Department of Community and Economic Development prioritizes some of their community development funding now to CLGs. I mentioned our staff architect will do some pro bono design work. So it's been, all those have given us some additional things to use as selling points. And then the last thing we did was, because we had 45 communities already certified, we said, all right, we're going to give you a pass to keep participating in the program, but we're going to give you 4 years to basically get your act together. And meet the new standards. So per the federal regs, because we substantially changed our guidelines, we drafted up a new certification agreement. We mailed it out to all of our 45 communities, and we said, we invite you to renew your vows. Here you have 90 days to sign this and get this back to us if you want to continue, and then 4 years to basically do everything that you don't have currently. Here's a worksheet that you can fill out to help you figure out what you need to do. And we did webinars. and 44 of our 45 signed the agreements and sent them back reasonably quickly. Some of them took a little longer to come to get that done, but surprisingly, some of the ones who had been the kind of sleepiest and most distant were some of the first to actually send in the new agreement, which was surprising. And the one that didn't, we don't really know why. They shouldn't have had any reason to be. They were otherwise kind of a preservation poster child. They just, for whatever reason, their borough council decided they didn't want to keep going. But we did have one new one come up and say, hey, we're interested. And then we had 12 new inquiries within the first 3 months of launching the new program. So those are all in various states of development and consideration. So I think we did achieve the goal of sort of reinvigorating things. And it was just a lot of paper pushing once we got through all of the conceptual rewrite part. So I'll just pause there and I don't know if anybody has any questions.
Yes, does anyone have any questions for Corey? Ultimately, the new certification agreements need to be forwarded to the National Park Service. Again, I've developed a letter just simply stating the necessity for the new certification agreement and that we concur, and the certification dates remains the same as the original certification.
So Curry asked if there was a public process. Yeah, so we followed, we wrote a blog, we did webinars, we mailed out specific questions. We, made a we did definitely make some defined efforts to get input. And we got a few comments. I think, like Carla was saying, not as many as I would have expected or hoped. But we did, do our part to try and get, particularly the existing CLGs to weigh in. And it did result in some clarifying language. I mean, there were some points that some folks pointed out, say, well, I just don't understand that what you're saying is not what you have written here. So that helped us to clear up some of the language concerns. The hardest part about it was honestly getting the certification agreements approved by our lawyers. We have some new attorneys, and that was the most, the hardest lift in terms of hammering out details. But we do have David, we do have all of the new certification agreements. They're squirreled away on a desk in Harrisburg waiting to be sent to you. So those are there. Your copy is coming.
Yes.
But we did screen the boilerplate language with John and Megan prior to distributing it. So that was all cleared by NPS before we circulated it.
Right, and the issue for me is, what do we do? And again, I created a letter to document what was done, so that we're all on record. Carla, do you want to speak to the sort of odd or funky things you found with Las Cruces?
Sure.
And that the situation was a little confusing.
Yeah, so just a little bit of background. The city of Las Cruces is New Mexico's second largest city, and in the 70s, it was its historic downtown was pretty devastated by urban renewal, and so there's been always this kind of attitude about Las Cruces, oh, there's nothing to preserve there, and so we've been really excited and happy that the city is interested in a preservation ordinance and CLG, and so they've indicated that they're interested in CLG certification. They did pass an ordinance back in December, and they'd had a committee that, excuse me, had been working on it for about 7 years, which included 2 city council people, and then they about this time last year, they hired a preservation consultant to do the final workings of the ordinance. And so the time was ripe and the city council was going to approve it. And so they brought it before the council in December and passed it. And so that's really an amazing accomplishment. And however, there were some aspects of the ordinance that were a little confusing because there are existing design review boards. There are two pretty substantially sized NR districts, and these design review boards were created to do review of those districts. And the design review board for one of the neighborhoods was still working, and they even had codified very similar regulations to the SOI standards. And so digging into more of the city's code, after meeting with David and John and Megan and John Heisch too, a few months ago, both David Banks and I dug in a little bit more into their code to see what was going on with what established those districts and how they might function with the new ordinance. And so it's prompted a conversation I've had with the preservation planner. The city also hired someone specifically to be the planner for preservation, which is also a huge step forward too for the city. And he's been in place for about a year and a half now. And so I've been talking with him along the way, and I was also involved in some of the later ordinance development meetings. So they've been working with us, and yeah, so it was a question of how to deal with the existing parts of the city code that specified design review, which would mean that a property in those areas would need to go to the design review board and the city preservation commission. So they would have a dual review, which seemed a little redundant. And so at David's suggestion, the recommendation was to sunset those provisions in the code, and that the preservation ordinance would stand as the prevailing code moving forward.
Yeah, and one of those districts, the planning commission had authority over it, and they usually, the planning and zoning usually are just enforcing building codes and uses and such. Excuse me. But it seemed like they were considering actually the preservation of these properties and the architectural features, which was one of the things that I had never seen before in any of the reviews of ordinances. So I found that very, very interesting. I'm done. If anyone has any more questions.
I just wanted to chime in. Corey mentioned that he kind of talked to us before they undertook this overhaul. And I think that's an important piece, even if, if you're doing a serious overhaul, especially for those of you that have a lot of CLGs. We really kind of went underground with his lawyers a little bit. And I think the Park Service proved helpful with that sometimes. And then we kind of came to an agreement, which David's talking about, the letter that we'll respond with, that he would submit those all as one group, and then we would handle it in that manner, because technically we are decertifying, recertifying. So I think it's a good idea to engage with us and just have that conversation and not kind of surprise us with a whole set of new certification agreements. And then what Carla, we were talking about is honestly, that's kind of what we're here for. So if you do have questions or something comes up that's strange, we're happy to get on the phone with you and have those conversations, and even talk with the city if necessary. So.
And to pick up on one of Curry's other questions about, getting a public process before we were, in sort of conceptualizing the changes. In our case, we we had a pretty good sense. We'd been doing like regular surveys, and we had pretty good relationships with a lot of the communities who were really active and kind of likely candidates for preservation or for to be CLGs. So we put together some draft proposals before we began really a lot of sort of public engagement, because one, we knew that there were constraints that we were going to have to meet. There wasn't sort of an undefined universe of like what we could do with this program. So we wanted to give some ideas, and we also felt like we were going to get better response if there was something to respond to, rather than just sort of blue sky a lot of different ideas. So but we did do surveys and sort of some gut checking along the way. So when we came up with our ordinance requirements, for example, we went through all of our existing CLG's ordinances and did like a checklist and to figure out if what we were asking was really too unreasonable, to see like how many would be totally like out of compliance. So because we didn't want to like disenfranchise anybody, we didn't want to kick anybody out. We wanted to encourage them to do better. So if it was like totally like, if there were going to be a lot of places that were totally off the map in terms of what we were thinking, then we sort of shifted back a little bit. So, we tried different, and then we created a lot of self-assessment worksheets saying like, here, if we did this, what would you think about it? Like, is this too much to ask of you? Again, we didn't really get anything that was like absolutely no. So I felt like it was good. What we're doing now at this point is I'm scheduling to kind of pick up the evaluation cycle. We're trying to do a lot of like informal assessments, sort of like an evaluation light with the existing CLGs, to go through and say, okay, now that there's like this new, process, let's talk about what you should be focused on for the next 4 years, how you could use the grant money to make that happen. Because when we come back, we're going to be in 4 years, we're going to do a more formal process where you're actually going to kind of get a grade. This is just a reorientation. All of the so Erica, yeah, all of the documents, the self-assessments, the guidelines, everything is on our website, which Elizabeth Rera, who is my boss, she posted in the chat here. So you can look on our website to find pretty much everything, all the sort of final products, all the technical assistance programs and things are all there.
Corey, I have a question, because I wasn't involved in the Pennsylvania procedure changes. You said that you analyzed all the existing CLG's ordinances. Were any of them, did they need to change their ordinance, any of them?
Yeah, basically every one of them will, in some way. There were no kind of gold stars, and again, this is sort of a quirky thing, but an example about what we were talking about. A lot of our ordinances, because of the way our enabling laws are written, a lot of the ordinances are written in a very static fashion. They're written for a single district, so they don't contemplate a designation process where you could add more districts, like change boundaries, you could add more resources to a list. They're written for a very defined set of resources or place. And we said, and we've been getting a lot of calls about from people saying like, so how would I change this if I wanted to add a new district or I wanted to change the boundaries? What do I need to do? So we made that a requirement in the CLG program. So you have to have a process with criteria. You should have had it all along, but now we're just simply saying you have to have it. So almost none of our CLGs have that language now. So they're going to have to go through and add those things. There's a surprising number that don't have economic hardship clauses. So, that's something they got to get in there. So, there was nobody that was spot on.
Okay. Well, Corey has set the bar high as usual for the rest of us. Okay, well, we have a few minutes left. Does anyone else have any questions for David or Don or the group kind of on this legal ordinance types of subjects?
How about I have a question for everybody else.
That sounds lovely.
I've often been curious, do you face challenges in distinguishing between the roles of the CLG Commission and the individual local historic district commission in terms of who does what?
Some of you will have that and some of you will not. No, pretty clear.
Well, could you just repeat that one more time? Like, what do you mean the difference between Historic District Commission and preservate? I don't understand the question.
I think what John's referring to is like you may have an overall historic preservation commission, but then you may have separate design review kind of commissions. Is that what you mean, John? Kind of like Alexandria?
Because each CLG has a CLG commission, which has certain responsibilities under federal and state rules. But in a lot of cases, there may have been previously existing local historic district commissions that did design reviews just for a particular historic district, not having jurisdiction local government wide.
Okay. Well, we do have an example of that, and it's one of our Tampa. Tampa is an issue where they have 3 separate boards in the city of Tampa. They have a board that does all the historic designation, but they do absolutely no design review. Then they have a board for design review that takes care of everything in the city except for Ybor City, which is the NHL district over there. And then there's a separate Ybor City board that does design review inside of Ybor and nowhere else. And sometimes it gets a little weird because in Ybor, you have like 3 overlapping historical designations over there. And Tampa is also one of our cities that has the non-recommended we review over NR listed properties. So they've got a local district in Ybor City, they've got the NR district in Ybor City, and they have the NHL district in Ybor City, and none of them have the same boundaries. So our partners at the local over there have become very good at jumping through a lot of hoops to get stuff done and to try to establish some sense of regularity. And I tend to defer to them when dealing with their own specific local things because this whole process resulted in several court challenges that occurred, well over 15 years ago.
What happens? Let's see. Yeah. So we have a lot of wonderful comments in the chat. So I think we can, I did figure out yesterday how to save the, so I downloaded yesterday's chat and I'll download today's chat. So we'll have that as a resource because y'all are putting a lot of good information in there.
And I actually think that there could be a whole session on reevaluating the whole program, rewriting procedures to go in a different direction or to enhance the whole program. I think there are a lot of issues involved in that.
Yeah, I'm sure some of you in some of your states are like, there's no way we could do that politically, but some of you are like, we need to do this. So I think it's possible. We also had a question about recording the presentation. So all the presentations are being recorded. We will figure out how to make this available be either on our YouTube site or on NAPC's YouTube site. Nathan, did you have a comment?
Yeah, it was actually to John's question. I don't know, Columbus might be a record. I think we have 6 commissions. Mm-hmm. Each historic district has its own. So we have Italian, German, and Victorian Village Commissions, the General Historic District Commission, and then the Brewery District. I think my math is right. But actually the biggest problem that I've seen is they don't want to create another historic district. There are a few areas in the city that would be great historic districts, but they're scared to death to do something because people in the city think, oh, well, we have to create another commission. To which I say, well, Cincinnati and Cleveland have one, and they're fine. Mm-hmm. I don't know why you guys do this anyway. I actually think they had to get really special dispensations, I think, from John to get into the program because they had, I mean, technically German Village pre-existed the city's local design review.
Mm.
So they had to get all kinds of weird stuff to get all of those in, and so they have to technically evaluate all of them every other year for us.
Last I checked in Los Angeles, all of their local historic preservation overlay zones has their own neighborhood commission. And I don't know how many they have now, because when I left in 2005, they had 20 or 21. So it's a lot.
The city of Louisville in Kentucky is very similar. They have a different architectural review commission for every local district. And then they have one landmarks commission that handles appeals and also local designations and National Register review.
Each of you in your state procedures specifies the composition and the responsibility of your CLG commission. And there's flexibility, of course, in how that's done. And in some places, I suspect that the individual district or community commissions sit as a subcommittee of the overall CLG commission. And in some cases, Nathan, I suspect it's a matter of the local historic district commissions pre-existed the certification process. And so how do you blend your forthgoing general requirements for a CLG commission with what's the existing or pre-existing situation on the ground when you get started?
In their case, all of theirs technically meet the general city requirements and the general CLG requirements. With OSU, it's a little bit easier to have more architects involved, although I'm sure not all of them have quite the level of staffing they would like. They've talked about blending them. I admit I actually put in to be the director of Preservation for Columbus, and they rejected me, but that I actually mentioned that, and they were, I had heard from people in our office that they're doing this, and they were like, there's no way on earth we're going to have the political power to do this, because the commissions, especially German Village, it's like they will jealously guard anything and will never let go. So Columbus at least will always have at least two, because German Village was especially a predator. But then I have one city that actually has the functions itself split up. So there's one that meets the CLG requirements, one does designation, one does the design review. There's two separate entities that do the design review, and the